I appreciate all of you spending time with me today going through the market forces that drive these contracts and the various forms of contracts that we've covered today, including LOIs, PSAs, IOIs, and acreage trades. But it's hard to understand a bit of these contractual terms and ideas if you can't see it in front of you. So these will be provided to you free of charge, but I wanted to go in and discuss some of them quickly so that you can see what we're dealing with here and what we're looking at. This is a short form PSA or letter agreement, as we called it earlier, that, as you can see, is only 2 pages. This can handle anything that a 30-page PSA can handle. But as we mentioned, you can go in and use one of these the same as you can a 30-page PSA, depending on if the deal calls for it. So therefore, this letter agreement template will provide the parties, will provide the sections of land, what depths, right? Mississippian, Woodford, Sycamore formations, what it should not include if it's limited, X amount of net acres of working interest into the land set forth herewith, located in a certain well, list the API number. And then you're going to have your contractual terms as we mentioned, right? You've already had the caption, the parties, the granting language, the formations, and the lands or the description. And then within, you've got your purchase price right here in paragraph 4 with the allocation of price per net acre as shown on the Exhibit A. Within the wellbores, then moving into the actual language, it automatically goes into due diligence and purchase date, right? You've got 30 days from receipt of the fully executed agreement to issue funds after completing due diligence. But if any part of the interest is unmarketable, in this case, we've defined marketable as what Oklahoma defines it as, is free of any existing title defects, demands, lawsuits, claim mortgages, or encumbrance or liens, you can enter into an additional 90-day curative period. Required curative instruments, it's always useful to list these out because although the state statutes and title examination standards give us a pretty good guideline, as we all know from running title, from being in this business, there's always nuances and there's always issues and defects that can come up on every deal. So parties understand that due diligence will give a title benefit or a title detriment, therefore the price will go up or down. And then we have your boilerplate provisions right here from 6 through 9 that are your standard miscellaneous provisions in a large form PSA. So that you have less than 2 pages and an entire deal can be done. Entering into seller buyer execution, you can enter a notary signature if you'd like, but it's not required under contractual law. Moving into Exhibit A, you'd have the schedule of assets, NRI, net acres, allocated value, including any implied price per net acre. You detail that here, and then you've got an entire agreement ready to go. Now, Exhibit B, I think that it's very, very important when you're issuing letter agreements or PSAs to handle any conveyancing documents at the same time. I know quite a few people will enter into a letter agreement without negotiating the assignment or the mineral deed or whatever form of conveyance you're going to use. But then after we get to the due diligence phase, we actually entertain what conveyancing document the party's intending on using, and if it's brought up at that time, there can be some discrepancies. I've seen deals almost fall apart at the very end because the parties could not agree on which conveyancing documents to use. Some didn't like the language, some didn't like the warranty, and with a short form letter agreement, you're typically not going to address all of those provisions as you would in a PSA. So here, the mineral deed, this assignment of oil and gas leases, includes an overriding royalty. If we did not address what net revenue in the letter agreement, but it was included in the assignment, you can see where that can become problematic if the parties don't agree. And then continuing the Exhibit A of the Exhibit B, this would be what you record in the county records. As shown by the purchase and sale agreement in front of you, which totals 27 pages, you can see a vast difference from that short form letter agreement we just looked at, right? We went from 2 pages and a couple of exhibits to quite a bit of boilerplate language that is included on a large scale acquisition, right? We go into what type of substances that are included in the hydrocarbon definition, although state law, every state law determines what hydrocarbon substances are passed. This particular PSA actually states it, right? We've got more so more formality in this one. As you can see, the mutual provinces, covenants, and conditions are going to be passed back and forth. And with this, there's going to be a lot more inclusions, a lot more exclusions, and a lot more language getting to the party's real intent. Now, depending on the deal size, this might not be necessary. If it's a smaller deal, if it's a couple wellbores or a couple leases, you might not need to go into the amount of detail that this PSA is involved with. But depending on your insurance, your indemnity, or your liabilities, based on what you're actually transferring, you might need this additional information and protections that this large form PSA can provide. But as you can see, the purchase and sale, the granting clause is pages long. You're transferring assets, leases, wells, the hydrocarbons, all the other agreements, including operating agreements, comm agreements, environmental agreements, any sort of unitization, pooling orders, all surface and subsurface machinery, all other additional obligations and rights that pass with the hydrocarbons and assets as mentioned above. Power plants, poles, line, transformers. This seems to be a bit of overkill, but on a large scale deal, we want every single thing buttoned up. In this case, even including the patents. I negotiated one of these PSAs that there actually was quite a bit of intellectual property involved with the performance and the operations of certain wells. There was a unique capacitor within the vertical wellbore that the parties had created, and they had patented it, and it was actually part of the sale price. So with this PSA, short form differs drastically, but you can see here we're not only negotiating the assets, we're including the intellectual property and everything that transfers with that, including any sort of infringement, misappropriation, or misuse of intellectual property and the liabilities that stem from that. So as I move forward this agreement, you can see it is quite arduous and cumbersome, but if it's a large-scale acquisition, you might want it. $120,000 is included in the purchase price. That probably would not necessitate this type of contract, but in this particular instance, a client or a seller wanted to use a large form contract. So you can see all of the closing obligations that I mentioned, the seller's representations that I mentioned, which are quite lengthy, right? They'll be conveyed free and clear of all liens, all mortgages, encumbrances. There's no production of or sales of any assets that are about to be canceled. There's other take or pay provisions, midstream provisions, anti-litigation provisions, no rights of first refusal, no other issues where there are, okay, so skip that part and then we go. As you can see here, representations of the buyer, also very lengthy, but not as much as the seller. This was the seller's agreement, and as you can see, the seller was representing quite a bit. Covenants of the parties, there's quite a few covenants listed here, including caps, deductibles, and indemnification. You do not see this in the short form letter agreement, but the parties that entered into this transaction and the purchase price necessitating such, there was quite a few conditions, precedent, and subsequent that needed to be closed. So as I move through, I won't read this entire agreement to you guys, but as you can see, it can accomplish the same conveyance, but with numerous other terms. The assignment, bill, and sale, there were numerous properties associated with this conveyance, including one for Oklahoma, one for Texas. And if you are going to negotiate any sort of conveyancing documents, I highly suggest you do it within the actual exhibit to avoid any complications that might arise later. As mentioned in the lecture, the lease exchange agreement obviously is a bit more in its infancy stage, right? Purchase and sale agreements and real estate contracts have been around since the beginning of time. Now, with lease exchange agreements, once we developed them, we had to tailor the form or the standard language to match the agreement according to our intent. So this is not going to read the same as a PSA, and although I won't read all of it to you, you can see it's 30 pages. So with a lease exchange agreement, there is quite a few provisions that you have to flesh out because it's not a buy-sell agreement. It's not an asset exchange. It is in the sense of you're trading it, but you're doing so for no value. So with that, the legality of it requires and necessitates quite a bit more language to be included in these. So I want you guys to take a look at these when it is most convenient. But as you see, the exchange property, you have to match it dollar for dollar, value for value, And what you're exchanging, as I keep moving forward, really is in the granting clause, and it's going to go into detail, quite a bit of detail, on which either grantor or grantee, because they're interchangeable depending on who's trading, which asset and which amount of lease is transferred. So you can see here there are quite a few sections depending on which form of assignment you're going to use. Some may be def limited, some may have an override, some have a different net revenue. Which ones you're going to actually transfer and trade. So you'll have party A granting all of its acreage here being valued within section 1.3, and then you'll duplicate it for the other party. And then you'll come down here and actually describe your calculation of the net revenue acres so that anybody subject to this agreement or any party reading this agreement or interpreting it, including, like I said, insurance companies, internal counsel, understands how you're getting to your valuation. What's really unique about these trades are the starting document actually might not be what you finish with. And what I mean by that is what acreage you start with the trade might not be 100% the acreage that you end with the trade. And that typically happens due to due diligence and defects. Once acres start falling out, you might have an imbalance, requiring one party to bring forward more acres to the table to balance out the net revenue acres or the trade. Due diligence is gone into quite a bit with these trade agreements due to the fact that that's really the only thing that matters. You have to value an acre for acre and net royalty acre across the board. So title defects and due diligence is very, very important with these. And as such, the language included within is pretty lengthy. Your standard closing conditions precedent you'll see as well. Parties can omit. Excuse me, I'm going to go back. But even though the form differs, you'll still see the standard terms that we discussed throughout our lecture today. Closing, conditions precedent, marketing agreements was quite hit on by these parties here, but you're going to have the same PSA contents that we negotiated up above. Post-closing and the closing documents, representation and warranties on both sides, liabilities, conduct of business, disclaimer of warranties, indemnification, and termination. All of these should read similar to the PSAs that we've touched on and also miscellaneous, but because this is a trade and not actually an asset sale, it's got to be tailored, because if you think about it, it has to be mutual beneficial, all right? An asset sale is one way. Seller sells to buyer. Well, here, these provisions have to go both ways to both parties. So the drafting of these takes quite a bit longer, but with that, as I mentioned, it's mutually beneficial. Okay, I'll just cancel it. I mean, that's where I'll end it. Yeah, and I think, with people can pull these up and play around with them, do all that, and email any questions.